Joanna Cherry.
Dame Rosie, it's a pleasure to follow the honourable and learned gentleman, and I found myself in agreement with much of what he said, and I think he made his points very forcibly. I rise, Madam Chair, to speak to amendments 32, 33, 34 and new clause 4 in my name, and to amendments 4 and 5 in the name of my honourable friend, the member for Glasgow North, and also to support those amendments in the name of my honourable friend, the member for Glasgow Central. I also want to make some comments about the clause stand part in relation to clauses 3 and 5 of the bill and the amendments that have been put forward, particularly by the Right Honourable Member for Newark, particularly in my capacity as Chair of the Joint Committee on Human Rights. But first of all, I want to turn to my amendments, which are about the impact of this bill in Scotland, and in which respect I'm speaking in a personal capacity. My amendments and those of my honourable friend for Glasgow North go to the extent of the bill, its extension to Scotland, and also to the date of its commencement in Scotland. Both of us seek to prevent this bill extending to Scotland, and in the event that we are not successful in doing that, my amendments seek to ensure that the bill will not extend to Scotland without the legislative consent of the Scottish Parliament, and that nothing in it will interfere with the supervisory jurisdiction of the Court of Session or its nobile officium, and I'll explain what that means a bit later. Madam Chair, we mustn't forget that the regime this bill seeks to impose, together with the Illegal Migration Act, is imposed on asylum seekers across the United Kingdom, not just those who arrive in small boats on the Kent coast. The UK government haven't forgotten that, and that's why they want this bill, with its far-reaching and unprecedented ouster clauses, to extend to Scotland. Accordingly, asylum seekers in Scotland looking to our courts for protection will find that the courts in Scotland have been emasculated in the same way as this bill emasculates the courts of England and Wales. Now, as well as having their jurisdiction ousted on certain matters of fact, as was debated yesterday, the Scottish courts will also find themselves unable to apply the Human Rights Act and unable to respect the United Kingdom's obligations under the European Convention of Human Rights and other international treaties. And I believe this constitutes a very serious intrusion on the jurisdiction of the Scottish courts, an unprecedented intrusion on the jurisdiction of the Scottish courts, and a very serious interference with the separation of powers between legislature, executive and judiciary. And I don't think this Parliament should be rubber stamping this bill at all, but particularly not in relation to Scotland. What this bill seeks to do in emasculating the jurisdiction of the Scottish courts in relation to asylum seekers is anathema to the Scottish constitutional tradition. People in Scotland don't want it. They didn't vote for it. In fact, actually nobody in the UK voted for this because the policy wasn't in the government's manifesto. But you won't find it, in contrast to England and Wales, Madam Chair, you won't find any opinion polls carried out in Scotland which support this bill. Now, as the great Scottish judge, Lord President Cooper, noted in the famous case of McCormick against the Lord Advocate in 1953, and I quote, "The principle of the unlimited sovereignty of Parliament is a distinctively English principle which has no counterpart in Scottish constitutional law. In Scotland, Madam Chair, it is the people who are sovereign, and that does make a difference to our view of how constitutionalism works and our views on the separation of powers. And it is of the essence of the Scottish constitutional tradition that executive power should not be unchecked. And this goes back in our history as far as the Declaration of Arbroath in 1320, when Scottish nobles asserting the sovereignty of the people of Scotland in a letter to the Pope told His Holiness that if the King of Scotland should ever seek to make Scots subject to the King of England again, they would kick him out and seek another king to defend him. So in Scotland, the sovereignty of the people is our guiding principle, not the sovereignty of the monarch, or indeed our own, or indeed this Parliament. So neither our Parliament nor this Parliament is sovereign, it is the people who are sovereign. Now, just turning to the jurisdiction of the Scottish courts, this Parliament, this Union Parliament, exists because of the Treaty of Union. Scotland has always had a separate legal system, and Article 19 of the Treaty of Union between Scotland and England protects that separate legal system, including its inherent supervisory jurisdiction, and including the nobile officium of the Court of Session, which is a power that the Court of Session in Scotland has to give remedies where otherwise there would be no remedy. And since the modern advent of devolution by virtue of the Scotland Act, the civil jurisdiction of the Scottish courts, including judicial review, has been a devolved matter and therefore one properly for Scotland's Parliament. So I believe that this bill is a grave intrusion on the civil jurisdiction of the Scottish courts, and that's the reason for my amendments. The Scottish Government is considering a legislative consent motion, and my Amendment 34 would ensure that this bill, when it becomes an act, would not come into force in Scotland without a legislative consent motion. And new clause 4, which I'm putting forward, would ensure that notwithstanding, I like that, a nice notwithstanding clause. I hope honourable members on the other side who've been so excited about notwithstanding clauses will support my Scottish notwithstanding clause. New clause 4 says that notwithstanding anything in this bill, if it were to become an act, the supervisory jurisdiction and the nobile officium of the Court of Session would be preserved. And in that way, I hope to ensure that asylum seekers in Scotland will still have the protection of the courts in accordance with our constitutional tradition. Just to explain, the nobile officium of the Court of Session is a noble office or duty which Scotland's highest court has. It's a sort of extraordinary, equitable jurisdiction by virtue of which the court may, within limits, mitigate the strictness of the law and provide a legal remedy to people where otherwise none would exist. I will give way, yes.
Without prejudice to the content of what she's saying otherwise, could I just simply say in relation to the notwithstanding, I'm extremely glad that the Scottish eagle has landed.
Certainly won't be supporting the other notwithstanding clauses in the bill, but I felt it was perhaps time we had a notwithstanding clause that benefited Scotland for a change. So my amendments, Madam Chair, they're designed to protect Scotland's courts and the Scottish constitutional tradition, and they're there to ensure that asylum seekers in Scotland might still enjoy the protection of the courts from the infringement of their fundamental rights. And that's what people in Scotland want, and that's been expressed repeatedly through the Scottish Parliament. So I am, of course, a Scottish MP and a member of the Scottish Bar, and I'm here to do what I can to protect Scotland and Scotland's legal system for the extraordinary attack which this bill constitutes on human rights and the rule of law. But, Madam Chair, I'm not a Scottish exceptionalist, and I recognise, as reflected in the House of Commons Library's excellent legal briefing on the bill, and indeed in the speech that preceded mine, that concerns about the impact of this bill on the rule of law and the Constitution are shared by many in England and indeed by many lawyers in England. And for every lawyer that has been cited by honourable members on the other side in favour of this bill and in favour of the draconian amendments to this bill, you will find 2 lawyers who disagree. And the library briefing, and it really is an excellent summary of the different legal views on this bill, the library briefing concludes, and I quote, "Tension between the sovereignty of Parliament to legislate and the role of the courts in enforcing the rule of law principle that executive bodies must exercise their powers within their statutory limits may be tempered by restraint on both sides. If either the courts or Parliament cease to exercise such restraint, significant constitutional uncertainty could result." Close quotes. And I believe that if we pass this bill, this Parliament will have ceased to exercise the restraint referred to there. It would be a major departure from such restraint. And I do believe, Madam Chair, that if this bill passes, I believe and I predict that we will see what might be an unprecedented constitutional challenge to an act of the British Parliament. I will give way.
The checks and balances which prevent arbitrary power. And she's right that in our constitutional settlement, that is central. But this is not the exercise of arbitrary power, because the bill and the amendments to it are quite specific about their provisions. So, for example, our separation from the international obligations that I know she holds so dear is very specific in the amendments that are tabled by my Newitt, specific to this particular measure, this legislation. This is not arbitrary, anything but.
what it does do, this bill, is it seeks to carve out a group of people coming to our country or within our country from the protections that the rest of us enjoy. And I think that history shows us that that sort of legislation can put a state on a pretty slippery slope. And that brings me to the arguments I want to make in relation to clause stand part for clause 3 and 5 of this bill. Now, the Joint Committee on Human Rights has not yet had the chance to complete legislative scrutiny of this bill, given the speed with which it has passed through the House. So we have not, as a committee, reached a concluded view on the bill. But before Christmas and before the second reading, a chair's briefing paper referring to the legal advice the committee had received was published, and it's extensively referred to in the excellent legal commentary on the bill published by the House of Commons Library. And it says this, inter alia, that the disapplication of the Human Rights Act in clause 3 of this bill is really very significant. Because, as I indicated a moment ago in my answer to the Right Honourable Gentleman, human rights are meant to offer a fundamental level of protection for every person on the basis of their humanity alone. And as our committee has noted in a previous report, if those protections are disapplied when they cause problems for a policy goal, they lose their fundamental and universal character. And that means that they lose the fundamental and universal character that characterises them. And this is arguably particularly the case when they are disapplied in respect of a particular group. And in this case, fundamental human rights are being disapplied in respect of migrants who come to the United Kingdom without prior permission. Now, bills that disapply parts of the Human Rights Act are not unprecedented under this current government, I'm sad to say. Both the Illegal Migration Act and the Victims and Prisoners Bill sought to disapply Section 3 of the Human Rights Act in respect of certain legislation. However, this bill seeks to disapply Section 6 of the Human Rights Act, and that's the obligation on public authorities to act compatibly with human rights. And that's never before been attempted, even by this government, and it represents a significant inroad into human rights protections. If we pass the bill with that clause there, it means effectively this Parliament is authorising public authorities to breach human rights. Now, that's an awful long way from what this Parliament intended when it passed the Human Rights Act and what the United Kingdom intended when it signed up to the Convention. Now, as we heard at some length yesterday, as a result of parliamentary sovereignty, breaching human rights, if we pass this bill, would be in accordance with our domestic law. But it will violate the UK's obligations under the Convention, because we cannot unilaterally change what the Convention says. And also, as the Bingham Centre for the Rule of Law have noticed in their briefing on the bill, if we disapply the Human Rights Act in the manner proposed, we're also breaching Article 13 of the Convention, which entitles people to an effective remedy. Now, I'm afraid to say that the amendments in the name of the Right Honourable Member for Newark, who's no longer in his place, his amendments to Clause 3 would make the situation even worse. And his amendments 11 to 12 appear to extend the disapplication of the Human Rights Act to anything done under the Illegal Migration Act that relates to the removal of a person to Rwanda. And that could potentially mean that the detention of people awaiting being removed to Rwanda and their treatment prior to their removal would not be protected under the Human Rights Act. Is that what this Parliament really wants to legislate for? And additionally, as the Right Honourable Member for New York seeks to do, he wants to extend the clause to disapplying Section 4 of the Human Rights Act as well. Now, the clause as it presently stands does not disapply Section 4 of the Human Rights Act, and that means that it would, if it remains as it is, be open for a court in future to declare that this bill, when it becomes law, is not compatible with this convention. Now, with the convention, that would be by way of a declaration only. It wouldn't affect the ongoing function of the bill. It wouldn't mean that removals to Rwanda could be prevented or delayed, but it would mean that this Parliament and government would have to decide whether any changes to the law should be made. And if we amend the bill to disapply Section 4 of the Human Rights Act. Again, that's something that has never been done before and something that would further oust the jurisdiction of our courts from saying to the government and the public what their view on the law's compatibility with human rights is. And finally, turning to Clause 5, stand part, I also believe that this bill shouldn't stand part of the bill. We've heard a lot today about honourable members on the other side of the House's concern about interim measures issued by the European Court of Human Rights. And the reality is this: no matter what this legislation ends up saying, it can only affect domestic law. In respect of the ECHR in particular, the UK will remain bound by the Convention as a matter of international law. And indeed, even if this government, God forbid, were to exercise the nuclear option to withdraw us from the Convention, thereby putting us into bed with Russia and Belarus, even if they were to do that, we would remain bound for a further 6 months after withdrawal takes place. And I hope they'll bear that in mind. So Clause 5 at the moment says that only a minister can decide whether to comply with interim measures, and the domestic courts should ignore them. It remains to be seen what a minister would do, but we all know that the Prime Minister has said repeatedly that he wouldn't let a foreign court, to use his words, prevent flights taking off, which indicates that interim measures may be ignored. Now, as I said in my intervention earlier on the Right Honourable Member for Newark, interim measures are made under part of the Court's Rules of Procedure 39. They don't form part of the text of the Convention ratified by the UK, but when we ratified that Convention, we signed up to the idea that the Court, the European Court of Human Rights, is the body that determines the meaning of the Convention, and it's held consistently since the case he mentioned in 2005 that failing to comply with interim measures amounts to a breach of Article 34. Madam Chair, interim measures are fundamental to any court. They are issued to protect the position of an individual while their legal rights are determined. All this fuss about people in their pyjamas in the middle of the night is just very silly. Judges in the United Kingdom, both in the English jurisdiction and the Scottish jurisdiction, are regularly got out of their beds in the middle of the night to issue injunctions in England, interim injunctions in England and interim interdicts in Scotland. It's a standard part of any legal system. And many of the concerns that the other side have expressed about these have now been addressed by the court in reforms which they are proposing. But any decision of a minister not to comply with the interim measure would therefore be inconsistent with our obligations under the ECHR. This means that Clause 5, if we let it stand part of the bill, will expressly authorise British government ministers to act in breach of international law. That is the reality. And I note that according to the Times newspaper, this is the advice reported to have been given to the government by the Attorney-General and the Minister, the Honourable Member from Mid Dorset and North Pool, when he was Solicitor-General. That doesn't surprise me at all. It shouldn't surprise anyone, because any legal undergraduate would be able to tell you that. So insofar as Amendments 23 to 25 state that interim measures are not binding, that is inaccurate as a matter of law. And we must understand that we'll be putting the UK directly in conflict with our international legal obligations. So, Madam Chair, I realise I've taken up a little bit more time than I'd intended, but I hope the amendments I've spoken to and the clause stand part would go some way to ameliorating this bill, but certainly even if they were to be passed, I would be voting against it. Thank you.